Intentional torts privileges, defense of persons and property. In this episode, we're going to continue our discussion of intentional tort privileges with defense of persons and property. These defenses apply where the alleged tortfeasor repels a threatened invasion of his legally protected interests by the person whom he eventually harms. There are three distinct defenses: self-defense, defense of others, and defense of property. The distinctions among them are pretty straightforward. For example, imagine you raise your hand to hit me, and I defend myself by hitting you over the head with my torts casebook, causing a concussion. If you sue me for battery, I will assert the privilege of self-defense. Now imagine I see you raise your hand to hit someone else, and I intervene and injure you. If you sue me for battery, I will assert the privilege of defense of others. Or I see you reaching for my iPhone to snatch it away, and I hit you over the head. If you sue me for battery, I will assert the privilege of defense of property. These defenses can be used to privilege battery, assault, or false imprisonment. Instead of hitting you over the head with a book to stop you, which would be battery, I might simply threaten to do so, which would be assault. Or I might lock you in a closet and call security, which would be false imprisonment. In many cases, the crucial question with regard to defense of persons and property is what degree of force is privileged. Here's the rule. The degree of force that's allowed is whatever force is reasonably necessary to repel the invasion of a legally protected interest and proportionate to the degree of the threatened invasion. Necessity and proportionality are distinct elements, both of which must be present for the privilege to be valid. Let's start with proportionality. If you raise your hand to slap me and I immediately pull out a gun and shoot you, a jury might decide that my use of force was not proportional to the threat you posed, and I will be liable for battery. Deadly force is generally allowed only to repel a threat of death or serious bodily injury to myself or to another person I'm defending. So if you come at me with a knife and I shoot you with a gun, that might be deemed proportional. Some jurisdictions also allow reasonably necessary deadly force to repel certain crimes, such as violent felonies, which you'll learn about in criminal law. Proportional non-deadly force is allowed to repel other harmful or offensive contact, confinement, or theft or damage to property. So if you raised your hand to slap me and I hit you over the head with a book to stop you, the force I used is greater than the force you attempted to use, but it isn't unreasonably disproportionate to the way shooting you with a gun would be. In addition to being proportionate, the degree of force used by the defendant must be reasonably necessary to repel the threatened invasion. Whether the degree of force is deemed reasonably necessary depends on the circumstances. Imagine you are approaching my house carrying a baseball bat. If I'm standing at my front door and I fatally shoot you from 10 feet away, the force I used may not be deemed privilege if, for example, I could have shouted a warning, which may have been sufficient to repel the invasion, or could have used the butt of the gun to hit you on the head, knocking you unconscious rather than killing you. Or I could have gone inside, locked the door, and called the police. If there are other things I could have done fairly easily that would have been sufficient to repel the threat, then I have a duty to try them first. If I don't, then my use of force may be deemed unnecessary. Note that a person may be privileged to threaten more force than he would have been privileged to use. So I might have been privileged to point a gun at you and shout, "Don't move," which would otherwise have been an assault, even if actually shooting you would not have been reasonably necessary and proportional. It's worth mentioning that the reasonably necessary requirement is modified in some states by special rules regarding whether a person owes a duty to retreat from a threat, by going inside, locking the door, and calling the cops, for example, or instead has a right to stand his ground. In many states, there is no duty to retreat if the threatened individual is in his or her own dwelling. In some states, the right to stand one's ground applies even outside the home. It's important to understand that whether there's a stand your ground law or not, the reasonably necessary requirement means that there is no privilege to use force after the threat has passed. Retribution is not privileged. For example, if you are about to throw a punch at me, then I would be privileged to hit you over the head with a rock to stop the punch. But if you punch me and then turn and run away, I am not privileged to throw a rock at the back of your head as you retreat. In that case, the force was not reasonably necessary to repel a threat. Finally, let's talk about what happens when the defendant makes a mistake. In some cases, the defendant says that she believed that the degree of force she used was reasonably necessary and proportionate, but in fact she was mistaken about the true nature of what was happening. Courts generally do allow for a reasonable mistake in cases of perceived self-defense. So if I see you raise your hand and a reasonable person in my position would have believed that you were about to slap me, then I would be privileged to hit you over the head with a book. If my belief is sincere but unreasonable, because a reasonable person would have realized you were simply raising your hand to ask a question and had no intention of slapping me, then my use of force will not be privileged. Mistake is less commonly allowed in cases where the defendant reasonably believed himself to be exercising force necessary to protect a third person or property. So if I see two people arguing on the sidewalk, and one of them raises his hand to hit the other and I intervene, it might turn out that they are simply filming a movie and no one was in danger. If my mistake was reasonable, some courts would deem my actions privileged, but others would not. In jurisdictions where mistaken defense of others is not privileged, I intervene at my own risk. To wrap up, let's go back to our general rule. The force used must be both reasonably necessary and proportionate. So if you are attempting to slap me, and you are much stronger than me, such that the only way I will be able to prevent the slap would be to stab you with a knife, my knife attack may be reasonably necessary. But unless a reasonable person in my position would have believed herself to be in danger of serious bodily injury, the use of deadly force is not proportionate, and therefore my knife attack not privileged, with the result that I would be liable to you.